Good morning, listening audience. Welcome to our fast forward seminar this morning on defending lawsuits. This will be a lot of fun. We'll give a few minutes for everybody to get online here. We've got a very interesting speaker today, a premier attorney in the field of defending trucks in truck crashes, as well as cargo claims, as well as personal injuries, but we'll get to there in just a minute. We will stay on time today. I was reminded by Peyton that attorneys charge by the minute, so we'll stay on time this week. Okay.
Sounds like a plan.
Okay, we'll give it another second or two, and we'll get rolling. My name is Mark Ray. I'll be facilitating today's presentation. I've got 34 years in the truck transportation industry. And we're going to talk today about lawsuits. I've seen a lot of discussions and decisions that are made in the freight industry that people always ask the question, well, we might get sued, or we could get sued, or is this something that we need to be concerned about for a lawsuit, which are very legitimate questions and concerns. However, they can't paralyze your operation. You've got to pick up and deliver freight. And today we're going to talk about the reality of defending lawsuits. They can be defended successfully. I have personally been involved with Peyton in lawsuits where we successfully defended lawsuits. So there's nothing to be afraid of, in my opinion, of a lawsuit unless you're not prepared. So we're going to talk a lot about preparation for that today. And without any further ado, Peyton, can you introduce yourself and we'll get going?
Hi, I'm Peyton. I'm originally from Dallas, but been to school all over the place, and I grew up driving cattle trucks out in West Texas. Wind up driving rock buckets to pay for school, pay for undergrad, and then was fortunate enough to still have my own truck. So if you ever see an 83-foot flat black 359, make sure you wave, because it's probably me. I've got the flying pig on the hood, and I'm sure I'll wave back. I drive that thing all over the country to races and conferences and that kind of thing.
Well, I've had the pleasure of riding. I asked Peyton if I could drive it. He wouldn't let me drive his truck, but he is involved in the industry, and we'll cover that here in a little bit more. So before we get started, litigation in the COVID world that we're in. I know there's some challenges with depositions, hearings, virtual juries, I guess. Can you kind of give us an update on how lawsuits are being processed today?
Well, what we're seeing is obviously, the COVID response differs from jurisdiction to jurisdiction. So it's not just a city by city issue; it's state by state and county by county. So it's thrown us not in limbo, but it has definitely slowed the process down. And judges that would normally turn decisions back the day I had a chance to go to that hearing and speak in front of them are now waiting a week or two, or maybe as long as 2 months to send these decisions back. All of my jury trials in the state of Texas have been pushed back that were set for mid-March through mid-May. So we don't know when they're going to actually set. We know that's going to have a waterfall effect, and I'm hearing similar things from my cases around the country. So it really has thrown us kind of into limbo, and it's a bit frustrating in terms of, we try and get expedient results, and the disparate response and action plans, if you will, have kind of thrown the legal community for a loop. But we are able to participate and communicate, obviously, by Zoom and things like that, but the trials aren't going forward.
Okay, well, I'm sure there'll be a lot of catching up to do once things are opened up a little bit.
Oh yeah.
Well, another thing, I know it's a lot of fun when the judge reads your motion for summary judgment has been approved, but that's not always the case. As we know, that's obviously what you try to do, is snuff them out at the beginning. I'm going to ask you to expand on this word defendability. What what can be defended and what do you need to be able to defend a lawsuit? And while you're answering that, though, I have a question for the listening audience on this issue.
Okay. Well,
so here's the question. While they're answering that, if you could expand on this, what's defendable, not necessarily if it's your fault or not. So the question is, what percentage of car drivers are at fault in a car truck fatality crash? And the choices are less than 50% or more than 50% of the fault belongs to the car driver and not the truck driver. If y'all could answer that while Peyton expands on this issue of defendability.
Yeah, Mark, when I think of defendability in a trucking case, I think of it from two perspectives. How do I defend the driver? How do I defend the company? Because typically the allegations against the company, I can get thrown out one way or the other if I'm aggressive about doing it and if the company is, compliant with industry standards. But in terms of the defendability on the driver's side, I'm looking for ways to prove he or she was not at fault. And I'm trying to prove that the physics don't add up to us having done anything wrong. And I'm trying to put it in terms that the judge understands way before trial. And what I found is that if you put it in front of the judge and you're aggressive about defending these types of cases, you're much more likely to get a positive result before you actually have to go all the way to a full jury trial.
Okay, so if it's your fault or not isn't always necessarily the defense strategy. The defense strategy can rely on, am I able to defend this thing? Do I have the documents and the dash cams and the statements and the things that are necessary to defend the case can be totally independent from was I at fault or not?
Right. Yeah. Do I have the evidence I need to prove that nothing we did or did not do caused that collision? And how we collect that data and information is key. You've got to get it done early on and make sure you have everything you need. You start marching forward after that.
Okay. Thank you. The next slide, please. The statistics show they're pretty obvious that 70%, the preponderance of evidence suggests that car trucks, the car drivers, are principally at fault in 75%. So that tells me that when you have a nasty, that you should be able to defend it 70% of the time. Is that what you see in the lawsuits that you're involved in?
Well, Mark, and here's the sad reality is that I would say probably 90% of the time it's the four-wheeler that's at fault. 90%. But the reality is that juries are very quick to give away your money, and they're very quick to give away the insurance company's money because they don't think of $1 million like you or I would think of $1 million. It's chump change to a jury. And so instead of winning 75% of the cases, there are very few truck cases that we see brought by or that are defended by most attorneys that are actually being won. They're probably winning 10 to 15% in spite of the statistics.
Wow. Okay. That's so Stacy, could you throw up the results of the poll? I saw it for just a second. 18% say less than 50%. So we're pretty accurate there. Okay. So so the fact is, if you have your documents and your information, your policies and statements and so on and forth, you can be successful in defending a lawsuit because 70% of them are not the fault of the truck. So that leads to another question I've got, and it's about discovery. And I'm going to ask the audience to answer another poll question. What percentage of lawsuits make discovery a request for documents? Less than 50% or more than 50%? And Peyton, if you don't mind, expand on this whole concept of discovery and how that can set the tone for a lawsuit.
Well, so discovery is a request for information, typically written information that we receive from plaintiffs in these collisions. And, we obviously send our own requests trying to figure out different things about the plaintiff. But the discovery requests that I get from the plaintiffs set the tone for the case because they tell me what this attorney knows about trucks and they tell me how much work he's put into this case up front. Because if he's using a boilerplate set of discovery that he copied from someplace, he's probably not thinking about this case specifically. But if he's tailored it to our actual facts like he should, it tells me I've got somebody that's paying attention and might know a little bit about trucks. So one of the things we try and do is that even though we get voluminous discovery requests, I do try and save my objections and my fighting with counsel. I save that ammunition for really important questions because I don't want to wear out my welcome with the judge. And I want to make sure that if we have to go down there and talk about whether or not I should have to give this page or that page, I want to make sure that I've got a solid footing on that ground, because if I don't, the judge is going to ask me why I'm wasting our time. So it really does set the stage for a case, but it's incredibly important early on to, one, have all of your documents and make sure your attorney gets them. That's one of the biggest challenges we see is that, we think we have all the records up front. We try to make an analysis of it and we realize, hey, we're missing something, or maybe this guy had a third file that nobody bothered to tell us about because they thought that was a good idea. So we want to make sure we've got all the records, all the documentation as quickly as possible so we can evaluate what our potential exposure is.
Can you give us a quick, short list of documents you could be expected to produce in a lawsuit?
Yeah, all right. That's a good question, Mark. Back in the day, I think you and I first met about 6 years ago, and we were running through a request for documents, if I remember correctly. And so we saw the standard request for logs back when logs were primarily paper. We saw requests for any GPS tracking information. Now I'm getting frequent requests for audio and video recordings, if any, that are associated with that driver and or truck. I'm getting requests for the DQ file. Obviously the employee file, if that's separate, and if there's a separate medical file, I'm getting a request for all of those basic records. But that includes your testing and your initial employment applications, your MVRs, all that information that you'd expect to see and that every plaintiff's attorney knows should be in there. That's what we need to see right up front to make sure we don't see anything glaring. And I'll point out one of the biggest issues I see when I inherit cases right before trial, because sometimes people realize, hey, we can't go to trial with the folks we've already hired. We need somebody that actually does this. I see a lot of times that the plaintiff's attorney knows more about trucking and knows more about what should be in those DQ files than the defense attorney that originally had the case did. And that's a problem because sometimes you go into a situation where there's more risk than people understood early on. Sometimes you're in better shape.
And the absence of documents is a problem.
It is. And it's an avoidable problem, Mark, because you guys have got a fantastic platform that maintains records and makes it, you can pretty much hit send and send me what I need to see early on. And that saves us so much time.
And sometimes sets the tone for maybe we need to settle this thing. Yeah.
Sometimes I have seen a few cases like that.
Yeah. Okay. Do you have the results of the second question, Stacy?
That's an interesting number.
Yep.
And Mark, I'll tell you, every case we get a request for documents at some point. So 89% of the folks got that right.
So your answer is 100% of the time you can assume that you will get a discovery request for documents in discovery.
I got a set of document requests the other day before the plaintiff had actually served my driver. He filed a lawsuit, never served him, but sent us discovery requests.
Okay. Well, let's get on with your presentation. If we'll go to the next slide, Stacy. Okay, there she is. If you see that guy going down the road, that's Peyton, and I haven't driven. I got to ride in that guy. So, Peyton, here you go.
And Mark, I will say I'm not biased at all, but that's probably the prettiest Peterbilt I've ever seen. Anyway, okay. So, COVID-19 has presented some interesting opportunities and some risks for the transportation industry. One, from a regulatory perspective, I think we've got a golden opportunity because we have Congress and Senate and the president's ear when it comes to getting things done quickly. And so from an industry perspective, there are a couple things I think ought to be on the forefront. One of the things I'd like to see would be a national tort reform initiative that actually limits some of the exposure that some of these companies have, or that we would have as we move from state to state. The individual states have been very successful with tort reform on the medical and personal automobile side, we need to see that same protection and caps on damages for big trucks. And if there are any industry reps out there, I'm happy to go with your $1,000 an hour lawyer and sit with them at Congress and make sure they don't misrepresent the trucks, because let's face it, trucks are a very specific breed. Now, maximizing the opportunity, hours of service. We all know that there are specific waivers that are available, or specific types of cargo that you can haul that you're not going to be held to the standard hours of service. Fuel prices, for those of you that aren't locked in at former standard fuel rates, fuel prices have provided an extra margin there for profit. Obviously, we're dealing with far less traffic on the road. I think we're going to see, I haven't heard any confirmation of this, but this is what I think we're going to see, is that as you've got, 26 million people out of work over the last 4 weeks alone, I think you're going to see more of folks that previously drove trucks consider re-entering the truck driving market, because that's going strong. So you might be able to address your previous driver shortage with drivers that are becoming available. Number two, in times of stress, you've always got the opportunity for new clients as people are trying to develop, create masks or whatever, and they're trying to ship them across the country. It gives you a new market, new opportunity, and there are more loads out there than you previously would see. The flip side of that is that we do have increased risk operating in this current environment. One, you've got your hours of service, which were expanded, but I can bet you every last dollar that we have, Mark, that if a wreck occurs and our driver was in excess of the standard hours of service, a plaintiff's attorney is going to argue that we should have done something differently or more safely, such as abide by the hours of service anyway, if our driver gets in a wreck. Now, that's a bit of a, you can't have it both ways, but at the same time, we do have to be aware of that. So, to the extent that we're running over our hours, over the standard hours, make sure that we've got all of our T's crossed and I's dotted, and make sure that we have our logs noted that we're hauling a waived load or an exempt load. One of the other issues we have is that state regulations are going to vary. And, that's just the fact of life now. You're driving from, Mark, I was telling you, I drove from San Jose back to Dallas the other day, and there's different states doing different things. And you never know who's going to have what open. Rest stops may be open, rest stops may be closed. May not even have bathrooms out there. You've got uneven DOT enforcement as well. As an example, I didn't see a single DOT officer in California, which is, as we know, unusual, but I sure saw a bunch of them when I crossed into Arizona. They weren't doing anything, but they did have the weigh stations open. Real life worry is simply driver amenities. I saw a lot of rest stations that weren't open, weren't available for the drivers, and then your weigh stations or your rest areas that were open were just packed with trucks, much more so than I've seen in a long time. And obviously, in my mind, one of the biggest risks we have is driver health. The facts of this disease are in. I mean, look, we've had 3 or 4 recent studies here domestically over the past couple of weeks that put the morbidity rate about that of the flu, so about 0.9 to 0.15, all right? So that's not a significant percentage. It's as dangerous as the flu is. However, the facts are also pretty clear that if you have hypertension or if you're obese or if you have diabetes, that is more common than not in people that actually do succumb to this. So we have to be aware of the fact that some of our drivers do have these types of issues, and it can be a factor we have to be aware of. All right, expanded hours of service. All right, just briefly hitting on this, we probably are aware of who qualifies for expanded hours of service. If you're hauling medical supplies or testing equipment, food, paper products, fuel, things like that, or if you're hauling key personnel, you're going to be exempt. We want to be careful with how expansive we view our loads, because if we're hauling a bag of dog food, we don't want to necessarily, just one bag, we don't necessarily want to think that we're exempt. We want to be really careful about that. And as Mark, you and I have talked about in the past, we always view things in kind of a worst case scenario. And, how would this be considered if a driver were to be involved in a collision and someone were to be second guessing me? And that's what happens in these lawsuits, is some plaintiff's attorney who's wanting to make money and put it in his own pocket is second guessing us. and trying to construe what we did as somehow unsafe. And next slide, please. Okay, what's not expanded is some of the driver requirements, all right? So here, if we have a driver whose medical card or CDL lapses during this time of emergency, we want to make sure that that driver goes in as soon as it's possible in his or her state and gets their card or their CDL license renewed. We want to make sure that we're keeping an accurate list of the drivers that do lapse to make sure and follow up that as soon as it's possible, they correct that, that lapse. Because we do not want to be in a situation a year from now where they're still expired, yet they're still running. Also, if we do have a wreck, we've got to report it, obviously. And we do want to make sure that we can get our drug testing done as soon as possible after that wreck, or document our extensive efforts to obtain that driver drug test afterwards if we ordinarily would do so, but can't in this case because of the lack of resources. One other thing, and probably the most important on this, is if you have a driver, I don't care if it's a waived load or not, and I don't care if this COVID thing has passed or not. If you ever have a driver that's telling you they're too tired or they need a break, give them a break. Even if you have to find a replacement driver for that load, you might be able to fire them later, maybe should, but whatever, if you have a driver that's telling you they're tired, that's a red flag for us, and a plaintiff's attorney will use that down the road if something were to go wrong to make that case more valuable. All right.
Yeah, I did have a quick question there, a comment. It's obvious the FMCSA is extending waivers to our drivers to help operate during these conditions. I also see that, as possibly a trap for our plaintiff's attorneys, specifically, transitioning from emergency to non-emergency loads, or the complications with getting a drug screen or renewing the CDL. And I think it's important for us to over communicate to the listening audience here that you as a carrier are responsible for exchanging this information with your drivers and non-drivers, so that next year you get lawsuit and driver didn't renew his CDL for a year, and he's under deposition, and his answer is going to be, nobody told me, I didn't know. And you know what the plaintiff's attorneys are going to go with that. So using the INFINIT-I platform to educate drivers and non-drivers about these waivers and everything else that's going on appears to me to be critically important.
Absolutely. I couldn't agree more, Mark. We have to have the records, and we have to have the documentation. The drivers have to know what is required and what's needed, and we can't let anybody fall through the cracks.
Right. And we can't let self-interpretation take over.
Agreed.
Okay. Next slide.
Okay. And we touched on this briefly, but to the extent that we've got extended hours of service and we've got lots of freight to be moved and fuel prices are low, let's go make some money. One of the things like we talked about is driver health is primary. We want to make sure that we've got, to the extent we've got folks that might fall into that at-risk demographic, that they're taking appropriate precautions. And then from our perspective, if there is a case, is a crash, we need to know early on what happened, and you need to have a plan in place to address a crash, when and if it happens. And we can go ahead and go to the next slide here. Okay, so this is going to apply to kind of our mitigation basics. This is going to apply whether or not COVID is a factor, all right? Is before a wreck happens, we need to have a plan in place, and that starts with the day you hire your drivers, all right? So what we want to do with our drivers is tell them when they're hired that they are representative of that company. I don't care if they're an owner-operator. I don't care what the situation is. They are representative of your company when a wreck happens, and you want to make sure that that driver knows what to do. That's going to involve being calm, cool, and collected, regardless of how offended or mad or scared they might be after that wreck happened. We want to make sure that that driver knows to get out of the vehicle, check on the other driver, minimize the talking, but try and take photographs of all license plates of witness vehicles that stop so I can go track those witnesses down later on. We also want to make sure that that driver is friendly, non-aggressive, and available for the police officer to talk to. 8 times out of 10, when I talk to the driver and talk to the police officer never actually talked to our driver to get his or her side of the story. And what that means is that a lot of these police reports simply faulted us because the four-wheeler didn't want to admit they were at fault. We wind up getting a ticket or get identified as a contributing factor, and that makes my job more difficult. So I need to be able to prove your driver and your company didn't do anything wrong, and that involves being able to find these witnesses. The license plates photographs are helpful. Photographs of the resting positions of the vehicles are also helpful, as are photographs showing skid marks, signage that tells us what to do, that kind of thing. What we don't do is have a driver or let a driver be aggressive or combative or accusatory. Our driver needs to be calm, cool, and collected. We also don't send out a bunch of emails or text messages or things like that about this wreck. You need to call your insurance carrier, and you need to call your lawyer if it's a serious wreck. And we can go ahead and go to the next slide, Stacy. And in that capacity, you got to remember, in most states, the insurance company has the right to retain the counsel that it sees, that it wants, okay? However, that doesn't prevent you as a carrier from going in and hiring somebody who actually does trucking as opposed to just being a standard insurance defense lawyer to keep an eye on and supervise how that case is handled. You got to hire the right team to make sure you get a good result. And I saw this question pop up from Mr. McConnell. The question is most cases actually, if you look litigation wide, most cases will settle before trial. Trucking cases, though, what we're seeing is more and more people are scared to try a trucking case because you can get your head figuratively blown off in these verdicts if you don't know what you're doing. I'd say probably 50% of my cases settle before trial, which is lower than normal. We wind up trying probably more trucking cases than most. But that's because we go in and we evaluate that case based on the risk, not based on some of the more some of the more scary jury verdicts that have been out there. We're looking at the actual facts, and we can actually discuss these cases. But you've got to hire the right team to be in a position to defend these cases. That means if we're dealing with a case that's in New York or LA or even in Fort Worth, which is 30 miles from here, I typically like to hire a lawyer the judge sees frequently. That way I'm not the new face if I don't know that particular judge. I then handle all of the briefing, the big arguments, and go in, but I want to make sure that that judge is familiar with our team when we walk in. And it's been incredibly successful for us over the years. Practical considerations. I want to make sure that if we have a significant wreck, or we think that this is in a risky venue, okay, someplace like Eagle Pass or anywhere in Louisiana or New York City, someplace like that, I want to make sure that we do everything we can to prove your driver's story early on. Otherwise, it's a he said, she said scenario, okay? What that means is I want to typically get an accident reconstructionist to go in and document how the vehicles came to be where they were when the police officer showed up. And I want to document that our driver didn't do anything wrong if we can do so. But the ability to do that, and the ability to measure the crush damage and to compute the physics that I need to defend this, that passes. As soon as those vehicles are moved or the vehicles are destroyed, time is of the essence. So you've got to hire the right team that knows how to defend your case. And we go to the next slide, Stacy. Okay. Hiring the right team is really the most important thing you can do when you're defending a big loss. And then 2, making sure you have a plan in place when and if a collision does happen, you're ready to go. And the biggest issue up front with getting the company out of the case and off that jury charge is making sure that I can prove as early as possible that you did everything right during the hiring and retention process with this driver. And if you've got all your documents in a row and you can get them to me early on, that saves us time. It saves us having to argue with plaintiff's counsel. And it really sets the tone for a smooth resolution one way or the other as we march towards trial.
So I'll steal one of your sayings, help me help you.
Yeah, help me help you. And that's one of the more frustrating components of this job, Mark, is that if people don't tell me early on, it can wind up being a surprise later on. And I can defend anything as long as I know what happened. And, that's why I always try and sit down with drivers and the risk safety guys as early as possible, because it's hard to pull a fast one with the trucking guy because it's what I do. And it's, if I can actually sit down and talk to somebody in person, we actually flesh out what actually happened. And we've been very successful in dealing with drivers, even if they don't normally like lawyers. I don't blame them, but we've been very successful in in being able to basically build a defensive strategy and making a case that would not otherwise be defensible, very defensible.
Well, thank you very much for that. I think it's obvious why you are maybe or becoming the premier truck crash defense attorney in the United States. So we appreciate your comments. I did want to just do a quick summary of the issues that we covered here today. Number one, truck crashes are defendable. I think we established that over 50% of car truck accidents that have injuries or fatalities, which are the ones that end up in lawsuits, can be defended. Would you agree with that, Peyton?
Absolutely. I mean, these cases are defensible. It's just making sure that you have all the ammo in place.
I have the ammo in place. So prepare now. Once you have the crash, you can't go back and reproduce documents. So the best response is to prepare now. And I think we all agree lawsuits are a part of our business in today's world. They're going to happen. If they haven't happened, they're going to happen. So preparation is key. Would you comment on that?
Absolutely. Preparation is key. If you do it up front, you don't have to worry about trying to gather everything at the last minute when something goes wrong.
And of course, discovery is going to tell everybody a whole lot about, is a responsible carrier? Do they have their documents in place? Are they making good decisions and policies? Are they communicating with their drivers and their non-driving staff? And in the absence of discovery, of being able to provide those documents, it tells a completely different story, which is, are you irresponsible and as a plaintiff attorney, I'm going to load up and go after these guys. So would you want to just summarize the discovery and how that can set the tone?
Yeah, just for our purposes, just assume that anything you retain can be obtained in discovery unless it's a communication with your lawyer about the case. So we want to be very careful when we document our files dealing with drivers and things like that, to document everything we need to, but to avoid documenting something that is counterproductive. And the reality is that discovery is a key element of what we do, because it allows me most of the time, probably 93% of the time, to tell a judge there's nothing the carrier did in any way that contributed to this collision. And yeah, maybe there's a question of whether or not the driver had something to do with this wreck, but at least the company shouldn't be in it. So while we're still going to defend the case, the company doesn't need to be on the jury charge, and the jury is sitting there thinking, well, the company is going to pay an additional amount of money, and it's no big deal because it's somebody else's.
Irresponsibility is much different than just a questionable decision.
Absolutely.
Number 4, FMC regulatory waivers. We've talked about hours of service. We've talked about the CDL renewals, drug and alcohol, but we need to be very careful operating under these waivers. And we also need to go above and beyond to document our communication and training of our staffs, driver staff and non-driver staff, of our understanding of these regulatory waivers, and that they do have a sunset. They aren't forever. Is that kind of the summary of the waivers that are ongoing?
It is. And Mark, I saw a couple questions pop up asking about the waivers. And one of the things I would say is that if we're using the waiver to run items, where you run qualified items to a distribution center, I would take the position that is a waived. You are operating within the intent of the waiver.
Right.
Also saw another question about common carriers versus private carriers. And I think that's much more of a gray area. I'd be pretty careful running as a common carrier if you're identified as a private, even though I don't really see any downside to it. I don't think DOT is going to mess with you right now. I don't see any downside from a legal perspective because you're still abiding by everything you need to. But I'd be careful because you don't want to raise any red flags.
That's correct. Yeah. But yeah, we've got quite a few questions here. And the last one, we can beat billboard attorneys. We can beat them. They do know our industry. They know our industry very well, as you and I know. But we can beat them. We can defeat. You want to just elaborate on the plaintiffs and the billboard attorneys, and I don't think they are sheltering in place during this time. I think they're active, looking for opportunities.
Well, plaintiffs' attorneys make a living not doing something nice for plaintiffs, but by putting money in their own pocket. And trucking companies are a rolling target. You go in different places in the country, and you can't go 5 miles without seeing a plaintiff's attorney billboard. Have you been hurt in a truck wreck? They're not out there to help plaintiffs. They're out there to put money in their pocket. Let's be clear. And these folks spend an obscene amount of time in their state plaintiff's attorney meetings for lawyers talking about ways they can increase their recovery from trucking companies. And that's part of the reason why you're seeing these insurance rates skyrocket, which has put some smaller companies out of business recently, is because these guys know trucking far better than the defense attorneys that are hired by the insurance company. And trucking is a very specialized area of law that you have to be educated on. And like I said, a lot of times these billboard attorneys, for all of their annoying behavior that you see on TV and in the billboards, kind of obnoxious, they tend to know trucking better than most insurance defense lawyers. So you got to be aware of that. But they're easily beatable. You just got to know what you're doing.
Just got to know what you're doing. Yes, I saw a picture of a scene, an accident scene a month or so ago, and sure enough, in the background of the accident scene is a big billboard of the Hammer. You know, call me if you've been in a wreck. So what can you say? Okay, well we are on time. I've left my cell phone number and email if you've got comments, questions, complaints, or you just want to shoot the bull. They're at the bottom of the screen. And Stacy, as part of the preparation that we discussed and defense that you can defend, we are able to offer a complimentary 30-day trial of the INFINIT-I Workforce Solutions program. It covers a lot of these discovery requests that you're going to have. It covers the training. It covers the information exchange. It covers corrective action. And the timing is now to prepare for that. So we are offering a complimentary 30-day trial. There's the phone number, there's a website address, and I think, Stacy, you've even got a pop-up for that. There you go. If you would like more information on the INFINIT-I Workforce Solutions about our complimentary 30-day subscription, just press yes or no, and we will certainly follow up with you on that free trial. I would very strongly encourage you to do that. I have personally been involved in lawsuits with Peyton where those documents that were produced were very, very important and set the tone for the defense strategy. So if you can answer yes on number one, we certainly would appreciate it. And question number two, would you like more information from Peyton and his team? If you've got an ongoing lawsuit that you say, I need somebody who can drive a truck and knows what I'm doing, or if you just want to say, I want to get his connection and contacts in the event that we have that, just press the yes button and we'll follow up with you on that. And we will, I think, the Q&A, did we answer all the questions that come in, or are there more questions out there?
There are a few more questions, Mark, that look pretty interesting.
Let me see if I can pull those up.
You know, Mark, one of the questions I saw that I thought was interesting was dealt with cameras. and that's probably one of the most common questions or observations I deal with when I talk to drivers at these truck stops,
Yeah.
is uniformly they start off hating the idea of Big Brother, and that's how they view camera, right? Like how they view cameras. But most of them have stories about how those cameras have saved their tail. I've got a couple of great stories about those cameras, and I personally like the outward looking camera as long as you trust your drivers, and that's key. As long as you trust your drivers and you think they're operating in a safe manner, I personally love cameras.
Well, and a triggered event from a camera without any corrective action can be a little tricky. And for example, a multiple hard brake that would come to a carrier, assigning them some corrective action, say I have taken action on this triggered event. You want to expand on that a little bit and documenting that so that you can.
Well, yeah, absolutely. And Mark, on that front, if we've got anything that we maintain and anything that we keep that reflects negatively on something our driver did or did not do, we want to make sure that we do take corrective action. However, we don't necessarily need to keep things. What I like to see is cameras that are just recording. And if we have a driver that is involved in a wreck, they hit send and they manually send me that video. And that way what we have is we don't have anything that's reporting. I'm perfectly fine with the systems that do report. We just don't want to save that kind of stuff. But if we've got a guy that is involved in a wreck and has that camera, like we had a case out in Louisiana where somebody called and said, Peyton, you're never going to believe this. And I didn't when he told me until he sent me the camera or the footage. He had a car slow down, cause a wreck, he pulls over, and then a bunch more people jump from a different car into that car. Everybody holds their neck, goes to the hospital, and then turn right around and filed a 6-person lawsuit in one of these plaintiff-friendly parishes. And if I had had that camera, that case would have been very, very dangerous. But as it was, some of those folks wind up going to jail for perjury. And that's it's a really forceful hammer to deal with these guys that are just making stuff up. But it is a two-edged sword, as you hinted at. I mean, if you've got data out there that shows the drivers having a bunch of hard braking incidents, or maybe what I look for is the lateral changes. If he's swerving from lane to lane, those are the kind of red flags that one would warn me as a risk safety guy that, hey, maybe we need to think about this driver. And then two, we got to do something about it. And if we can't get it fixed and get it corrected, then we got to find another driver.
Right. Well, that's a great question, Peter, and hopefully we answered it. And I guess I could point back to the data that supports that 70% of the car truck accidents that result in an injury or fatality are at the car's fault. So cameras can help you out in approximately 70% of the events that you're involved in. We've got another question here that's interesting about discoverable. Should we take a statement by us if our driver is involved in a DOT reportable accident, and would that be discoverable? Peyton, you want to expand on that?
Yes, sir. The short answer is
great question.
It's a fantastic question. And Doug, thanks for submitting that. This is one of those issues that, yes, it's going to be discoverable unless a lawyer is participating and requested that statement be made. I like to see statements because I think that's a responsible question the company should ask in every incident, or at least most incidents. I do like to shy away from an official preventable, non-preventable determination because I think it's unnecessary. I think in most cases there's always something that could be done differently, but fortunately for most truck drivers, we're good at what we do. And if you're doing it right, we didn't actually cause the collision. So I don't think the preventable, non-preventable really helps us in terms of defending the case. And, it's not going to cost us any credit with the judge if we say, Judge, look, there was a wreck that happened, and we, with today's billboard attorneys out there every 5 miles, we just wanted to make sure that we got a lawyer involved as soon as possible. So we never made that formal determination. But yes, he still drives with us. Or no, that driver is no longer employed here.
Thank you. Well, that pretty well wraps up our webinar. Again, I would like to encourage you to accept the complimentary 30-day trial. The phone number 866-904-5087 for that free trial. And Peyton, we certainly appreciate all that you do to help us defend our lawsuits and our trucks from the plaintiff's attorneys and the billboard attorneys, and help us prepare for that. Thank you very much.
Thanks,
Thank y'all, and we will see everybody next Thursday at 10:30. Thank you very much.